So the name of the chapter we are going to start in this particular thing is unit number 2. Name of the concept is consideration. First of all, everyone, all the participants, do you have the access to this document? Everyone have the PDF of this particular contract act chart, sir? First give a proper reply. Let's go very fast and complete. 5 marks, pakka. Listen to this 45 minutes, 35 to 45 minutes. I will not take much of your time. I know how important your time is now. I will complete what is required from the exam's point of view. How to get the 5 marks, I will tell you. Properly listen to each and every word that I am going to discuss today. 1000% question will be coming and you will be writing well. Okay, one. So let us move on into the main concept. See, name of the chapter is consideration. Consideration is the unit number 2 of Contract Act. Unit number 2 of Contract Act. The best method to prepare Contract Act other general contracts is first complete, as I already said, 1, 2, 5, 6. Okay, na? In the 2, 5, 6 are very simple. So let us first cover those. In this session, I am going to cover consideration first. Okay, wa? Less time, more concept and more marks. This is our target now. So let us start with the concept of consideration. See, what is consideration? This is one question that asked for 3 times in exam. They will ask you define consideration. What do you mean by consideration? Consideration means something in return. But how to write? Let us see. The term consideration is defined in section 2 class D of Indian Contract Act. Section number, if you remember, you write down. If you do not remember section number, nothing will happen. No need to write. But don't write wrong section numbers. Okay. Next. So the term consideration is defined in section 2 class D of Contract Act. Point 1. Point 2. When at the desire of the promisor, the promisee or any other person did or abstained from doing or does or abstains from doing or promises to do or abstain from doing something, such an act or abstinence is called as consideration for the promise. Sir, what is this, sir? Same thing he is saying once again, same word is coming here and there. See, my point is, what do you mean by consideration? If a question comes in exam, you have to write the definition. What is the basic definition that was provided in Contract Act? Contract Act, the basic definition that they wanted to convey is, see here. First one. There are 2 parties, promisor, promisee. There is a third person as well, any other person. Sir, what is this promisor? Promisee and any other person. Contract ki 2 persons are required. Promisor, promisee. Who makes the promise is a promisor. Who accepts the promise is a promisee. Correct? Now what will happen? Consideration should be paid by promisor to promisee. Correct? Or sometimes a promisee to promisor, depending on the type of contract that we are entering into. Okay, wa? So what will happen? Consideration should start from the desire of the promisor or promisee. That's why, see, when at the desire of the promisor, when at the desire of the promisor, promisee or any other person, promisee or any other person did or abstained. Like that they said the definition. Easy way I will tell you, listen carefully. In a contract, there are 2 parties. One is a promisor, another one is a promisee. I will give you an example. There are 2 parties, seller, buyer. Seller, buyer. Okay. Who promises to sell? Seller. Who promises to buy? Buyer. There is a reciprocal promise. Yes. Making a agreement. Yes. Goods are legal goods. Yes. Enforceable at law. Yes. Therefore, contract will be created. There should be some consideration between both of them. Yes. Who will fix the consideration? Who will fix the consideration? Consideration will be fixed in this case by the seller. Okay. The first person who promises to sell, this fellow will fix a consideration. Okay. Payment will be made by whom? buyer can make a payment, or even a third party can also make a payment. Why third party will make a payment? Example, there are three parties A, B, C. Okay, what? A promises to do something. A promises to do something. Okay. Next, A promises to do something. B promises to pay consideration. Promises to pay consideration. C has to pay to B. Now, instead of C paying to B and B paying to A, what B directly can tell? Mr. C, don't pay to me. Okay, don't pay to me. Directly pay to A, such that two rounds can be adjusted directly. Repetition one more time for those who do not have a clarity on Contract Act. One more time I am repeating. Okay, see here. A, B, C. Three parties are there. A promises to do something. A promises to do something. B, first thing. That's why, see, when at the desire of the promisor, the promisee or any other person did or abstained from doing, or does or abstained from doing, promises to do or abstained from doing something, such an act or abstinence is called as a consideration for the promise. Okay, means what? There are two parties, A, B. Third party came into picture, C. Let us first try to understand between A, B. A said that he will give coaching for CA intern. Okay, CA intern. B said that, yes sir, I will definitely pay you rupees 50,000 for entire course. Okay, well? Now what doubt will come? A is promising to give a coaching, B is promising to give consideration of 50,000. Now promisor means both are promisers only. Yeah? Yes or no, everyone? If you observe, both are promisers only. A is promising that he will give coaching. B is promising that he will take the coaching and pay 50,000. Then who is a promisor here? That's what question I wanted to ask you. That's why I told you. Contract Act, if you see the chapter, that will be very easy. But you go deep into the analysis, lot many doubts will come in mind. Now I am asking everyone, A promised to give coaching. B promised to pay 50,000. Now who is the promisor here? I will give time. Read the content properly. Again, I am asking the question. A promised to give coaching. B promised to pay consideration. There are reciprocal promises. Means both of them are promisors. Then about whom the definition is speaking? Read definition one more time. Okay. So now listen. Now listen. Let me put a clarity on this particular issue. See here. See. Let us read the definition properly. When at the desire of the promisor, the promisee or any other person did or abstain from doing, does or abstain from doing, promises to do or abstain from doing, is called as a consideration for the promise. Is called as consideration for the promise. Okay. First, listen carefully. I'll explain. A, B, two parties are there. Last time before exams you are listening, please listen carefully. A, CA coaching, at CA inter coaching. Okay. B said that he will take coaching. Okay. Now listen carefully. Which chapter we are reading? Consideration chapter. So consideration chapter already consideration will not be present. In this chapter, consideration will come into picture. Without consideration, remove the concept of consideration and see who is the promiser, who is the promisee. We are reading a consideration chapter. Means consideration is not yet coming into existence in the contract. Agreement, the consideration concept not yet come. Without consideration, remove everything and tell me who is the promiser and who is the promisee. Everyone. Now we are in consideration chapter. Therefore, what we are doing, consideration is there. B is promising to pay consideration. Forget about it. Consideration chapter, consideration now coming into picture. Till now, consideration concept illa. Now, without consideration, you see and tell who is the promiser, who is the promisee. Now you came into line. Okay. This is what they wanted to tell. Who is a promisor? Promisor to a contract, not promisor to the consideration. Understood the point or not? Now consideration came into picture. A promised to give CA intercoaching is a promise made. To whom? Mr. B. A is a promisor, B is a promisee. B is a promisee. This is a number one. Okay. Number two. Promisor will fix consideration. Promisee will fix consideration. Next one. Promisor will fix consideration. Promisee will fix consideration. Who will fix consideration? I will give CA coaching to you. You will fix the fees, or I will fix the fees. A will fix or B will fix the price. Tell me. Who will fix the price? Use mind. Day. Some people are answering wrong answers. Mula illana. You are having exam. What is that answer? Who will fix the price? Now, 99% of all the students, what they answered? Promisor will fix the price. Now you came to line. When at the desire of the promisor. So, fixing the price should always start from the promisor of the act. Everyone understood the point clearly? Consideration fixing should always start from promisor, not from promisee. Promisee will pay consideration. Understood the point or not? Everyone, clear to the point? Now, you people, all of you can genuinely tell, did you really understand this concept in the same way before? Consideration you should remove and then see who is a promisor. Did you learn in the same way before? Everyone? There is all the problem. See, contract act problem, I will tell you. Everyone will think that they understood contract act, but actually no one will understand that in a right way. If I ask a question, see how wrong answers came before. Who is a promisor? Yeah, technically speaking, A promising to give coaching, B promising to pay consideration, then both are promisors only. A is a promisor for the act, B is a promisor for the consideration. We are reading a consideration chapter. So you should not see the consideration part. Remove consideration and see who is promising. That is the right way of understanding the provision. Clear, everyone? Okay. So, when at the desire of the promisor, promisee or any other person did or abstained from doing. Abstain means sometimes not doing something is a consideration. Not doing something is a consideration. Okay, wow, everyone? Can you go into the next part? Everyone, can I continue? Okay, so I'm really telling, if you understand this meaning, chapter will be completed in next 20 minutes. Problem is with understanding the foundation of consideration concept. So what is this consideration? There are two parties, promisor, promisee. Promisor, at the desire of the promisor, consideration will start. Promisee or any other person will either do something or abstain from doing something as a consideration, For example, see here. A said to B, I will give CA inter coaching. Okay. B said that, yes, I will take the coaching. Now two parties entered into agreement, promises made. One is a promisor, one is a promisee. Now, what B should do to A in order to give this coaching? What B should do? B should either do something or not do something. Okay, not do something. What is doing something? Pay rupees 50,000. Pay rupees 50,000. Now he is doing something. He is doing something. This is called as what? Act in return. Act in return. A gives coaching. B does an act in return called as paying 50,000. So this 50,000 is called as a consideration. 50,000 is called as what? Consideration. Okay, next. See here. A said to B, I will give CA inter coaching. B said, yes, I will take the coaching from you. Okay, wow. B said that I will take coaching from you. A said to B, do one thing. I don't want anything monetarily. You should not fail in the exam. That's it. I will give coaching to you. But your consideration should be, you should not fail in exam. Now, what is the consideration? Not failing in the examination, making me proud is a consideration for this contract. This is abstinence to do something. Means what? You should not fail. That's all. As a consideration for my contract. Everyone understood the point clearly? Yeah. Understood the concept clearly, yeah, everyone? Okay? Or I will tell, you should not join elsewhere. You should not join elsewhere. That is a consideration for my contract. So consideration need not be always in monetary. Consideration can be sometimes not doing something for my benefit is a consideration for the act I am doing to you. Clear, everyone? So listen carefully to the point here. Always another party need not pay in rupees or dollars something. Doing something, not doing something also can become a consideration sometimes. Not doing something can also become a consideration sometimes. Third one, A, B. A said that I will give CA inter coaching. B said that yes, I will take. Okay. Who fixed the payment? A said pay 50,000. C, who is the caretaker of B, said that I will pay. This is allowed. This is allowed. That's what they said here. The promisee or any other person did or abstained from doing, does or abstain from doing, promises to do or abstain from doing something, such act or abstinence is called as consideration. So payment of consideration can be made by promisee or any other person. But desire of the promisor only consideration should first move it. I completed the basic intro to the consideration concept. Can we continue with the next one? Everyone. Up to here, if you are comfortable, we'll go into the next one. Everybody clear? Okay, let's start. See, consideration chapter characteristics of consideration, first one. Doctrine of privity of contract, second one. No consideration, no contract, third one. That's all. If you study these three properly, 1000% I am giving you guarantee, you will get full marks in exam. Okay, well, let's see. Fastly, I will continue. Please listen carefully. The consideration must move. What we are reading? Characteristics of consideration. Ante, ee definition ki post-mortem. Each and every point in this definition we are going to reread. Okay? Consideration must move. Means must be done or promised to be done at the desire of the promisor. Just now I said that fixing of remuneration or consideration should be done by promisor. Done by promisor at the desire of the promisor. Okay. But what other person has to do? He should do an act or he should abstain from doing something. Which forms of consideration must be promised to be done according to the desire of the promisor? Means what? Another person should either act to do, okay, or abstain to do something. That will be the consideration. Act means what? Pay 50,000 is an act of doing something. Okay, pay rupees 50,000 is act of doing something. You must pass. It is an act of doing something. You should not fail. It's not doing an act, which is also called as an abstinence. You should not join elsewhere. This is abstinence from doing something. So therefore, an act or abstinence which forms consideration for the promise must be done or promised to be done according to the desire of the promisor. Simply to tell, fixing of amount of consideration or what to do as a consideration or what not to do as a consideration will be fixed by the promisor. Simply to tell, promisee should not presume that, okay, this is a proper consideration. I am running an institute. You came to me. You said, I want CA inter coaching. I said, yes, sir. These are all the faculties. These are all the subjects. These are all the books we will give. Okay. Then you only told, okay, for this, 40,000 is the right amount. Who are you to fix? Yeah. Fixing should be done by the promisor. If you like, you join and pay. Or if you don't like, you can leave. But who are you to fix the pricing? So therefore, consideration should always move from the promisor. Payment can be made either by the promisee or by any other person. Okay, done. Sir, up to here, everyone understood the point clearly? If you say yes, I will move to the next one. Fast. We should do question bank also. Yeah. Next. It may move from the promisee or any other person. Desire should be of the promisor, but payment can move from any person. So consideration may move from the promisee or if the promisor has no objection from any other person. Either I can pay or some other person on my behalf will pay. There is no compulsion that only you should pay. Where it was said, Chennaya versus Ramaya, very, very important case law. In this Chennaya versus Ramaya case law, what happened? An old lady made a gift of her property to her daughter with a direction to pay a certain sum of money to the maternal uncle by way of annuity. Annuity means every year. Okay. See what happened. There is a lady gifted property to her daughter. Let us say house property is gifted to her daughter. Okay. And she said very clearly that every year rent will come, but that rent please pay to Mr. C, some person, by way on every year basis. On the same day, daughter executed writing in favor of brother, agreeing to pay annuity. The daughter did not, however, pay the annuity and the uncle sued to recover it. It was held that there was a sufficient consideration for the uncle to recover the money from the daughter. Read the case law clearly. If they ask in exam, you will be able to write. Okay? Read this case law properly. Take a minute time, no problem. But 5 marks chapter, don't take it as a grace. Read it. Okay, well, see what he does mean here. See here what happened. A gifted house property to B. Okay, said that from this house property, income will come. Transfer it to C. Transfer it to C. Okay. Who said? A said to B, I am transferring you house property. From that income will come. Annually, that income should be given to C. B agreed to do that. B agreed to do that. That's it. If B agreed to do that to C, there is enough consideration between B and C. Enough consideration between B and C, because payment need not be made only by A. Any other person also will be liable to pay to C. Okay. So now what they said in this particular section, it may move, means a payment need not be made by A. Payment can be made by A or even by B, but benefit should be taken by that maternal uncle C. Okay. Next. Consideration can be past, present, or future. Sir, what is this past, present, future? Okay. Listen. I have done an act before. For that, I can ask consideration now. I am doing an act now. For that, I will ask consideration now. I am doing an act now. For the consideration, you can pay in future. So, if you have done some act before, for which you are asking payment now, past consideration. You are doing something now and asking now. Okay, that will be present consideration. I am doing an act now, but I will take money in future. That's a future consideration. It can be executed or executory. But in England and English law, post consideration is no consideration. Means act done before, for the consideration now, that is not accepted in England. In India, it is acceptable. Next one. Consideration need not be adequate. Sir, what is this concept? Listen. I will give you, listen carefully. I will give you, say for example, 1 kg gold. 1 kg gold is 1 crore 20 lakhs today. Let's say for example, okay. I will give you gold. A promised to B that I will give you 1 kg gold. B promised to A that he will pay 80 lakhs. Okay. Now the amount of gold transferred and the payment made, both are not matching. Adequacy is not there. It's not adequate. No problem. That's the income tax problem, but not the problem of contract act. Contract act plus something should be there in return. I'm not saying that exact amount should be there in return. So consideration need not be adequate. Consideration need not be any particular value. It need not be approximately equal value with the promise. Are you understanding? But it must be something which the law would regard as having some value. Okay. It can be below market value also, no problem. See, gold you are giving. For that I am giving you 80 lakh. 80 lakh is having a market value or not? 80 lakhs is a valuable amount or not? That's it. You pay 10 rupees. That's it. No problem. Adequacy need not be there. Consideration should be there. That's all. Understood? Next. Consideration may be executed or executory. Just now I told you executed means already paid. Executory means yet to be paid. A pays, example I have given. A pays rupees 5,000 to B. And B promises to deliver him a certain quantity of wheat within a month. Now what happened? I paid consideration. In this case, A pays the amount, whereas B merely makes a promise. Therefore, consideration paid by A is executed. Already I paid. Whereas consideration promised by B is executory. Is a executory. Means what? Your work is still pending. My payment is made. Consideration is executed, but contract is still executory. Next. It must not be illegal, immoral, or opposed by public policy. A consideration given for an agreement, which must be a lawful one, where the consideration to the contract is illegal, immoral or against public policy. Court do not allow an action on such contract. A simple concept here. A entered into contract with B to kill C for that 1 crore consideration. Okay. B went and killed C and came back to A for consideration. A said that I will not pay. Can he file a suit in the court? No. Because the act for which you are putting consideration is immoral or against public policy. Next one. Consideration must be real and not illusionary. The consideration must be valid. Okay, to be valid, must be real, valuable, and must not be imaginary. Means something which is not there, that you should not give as a consideration. Understood? Magical powers I will give you. Once you do that act, means magical powers are not there. Something illusionary, you should not create any consideration. Consideration must be real consideration. It need not be of equal value, but it should be real. For example, I said I will give you 1 kg gold. You said that I will give you 1000 kg silver, or I will give you 100 kg silver. Like that you can do. Or I can give you 10 kg silver. Some agreement should be there as a consideration. It should be real. It should be real, but not imaginary. But not imaginary. Okay. So these are all the points. First of all, we completed chart number 1. Everyone in the class, did you understand all the contents of chart 1 or not? Everyone. I don't want silent from anyone. If you want to be yourself present in the exam hall, don't be silent now. Be expressive. Tell your answer. Did you all understand up to here? Okay, done. Super. Next one. So what we completed? Characteristics of consideration completed. Next. Main point, let us complete first. Privity of contract. Privity of contract. So what is it? Let us try to understand first. See the screen. Let me make it full screen. Since a contract is a private relationship between parties who make it, the rights and obligations under such a contract is strictly confined to them. This is known as doctrine of privity of contract. It is a general rule of law that a person who is not a party to contract cannot sue. The rule is stranger to a contract cannot sue, but a stranger to a consideration can sue. Sir, I did not understand. Paragraph is there na, that you must write as it is in exam, or else they don't give marks. This line will be having 2 marks value. Privity of contract question comes in exam. First you need to write that paragraph. First thing. I will tell you how to remember. Contract is a private relationship between the parties creating the contract. Repeat again. Everyone repeat. Contract is a private relationship between the persons creating it. Repeat again. Contract is a private relationship between the persons creating it. Point 1. Point 2. Therefore, rights and obligations on such contract is strictly confined between them only. Therefore, rights and obligations on such contract are strictly confined between them only. That means a third party means a stranger or a party who is not a part of the contract cannot sue for the contract, but they can sue for consideration. Sir, I did not understand, sir. What is it actually? Read the paragraph one more time if you could not understand. Okay, well, everyone first reply. Did you read that paragraph? Everyone give a reply. Did you read the paragraph? I gave you 4 minutes time, 4 minutes time almost. Yeah. See here. What do you mean by this concept? Let me explain. See, this requires some explanation. One time you listen, life again you will not forget. Please listen. A, B, two persons are there. Correct? What they are saying is, listen carefully. A, promise to sell goods. B, and pay rupees 1,000. Okay. Okay, and pay rupees 1,000. A, sell the goods. B, will buy the goods and pay the promise and pay the 1,000 rupees consideration. Okay, up to here everything is okay. Contract is entered between both of them. Okay, reciprocal contract entered into by both of them. It's a contract happening between both the people. Sorry. Now listen carefully. So A, sell the goods, B, buy the goods and pay rupees 1,000. Up to here clarity came. Now what happened? Let us try to understand. Now what happened is, A, sell the goods and B, promised to buy the goods and pay rupees 1,000. Okay. On the due date, listen carefully. On the due date, A did not sell the goods. A did not sell the goods. C, customer to B. Okay, customer to B went to court and filed a suit against A, saying that A did not sell the goods to Mr. B because Mr. B said that he will sell those goods to me. If he would have sold to him, he would have sold to me. Therefore, I am suing him for not enforcing the contract, for breaching the contract. C wanted to sue A. This is called as stranger to a contract cannot sue on the contract. Stranger to a contract can sue for consideration, but not for contract. Simply to tell, if A do not enforce the contract or breaches the contract, B only will have a right to sue A, not some third party. A stranger to a contract will not get any rights on contract, may get rights on consideration. Sir, what do you mean by get rights on consideration? I will give super duper example. Before that, first listen to the first area. What is privity? Normally, contract is a private relationship existing between two parties. Okay, two parties. One person promises to do something, another person promises to pay something as a consideration. It's a private relation between two parties. In failure to enforce a contract, only one of the party can sue another. A third party who is not related to the contract cannot sue on the contract, but they can sue on consideration. Sir, what do you mean by sue on consideration? That I am going to explain you now. Okay. So before going into that, up to here, everyone, C cannot sue A, being a stranger. Understood the segment clearly or not? First, I want reply for this. Everyone. Everyone, clarity, yeah? Okay, done. Now see here. Since a contract is a private relation, rights and obligation are strictly confined to them. This is known as privity of contract. Okay, privity of contract. It is a general rule of law that a person who is not a party to the contract cannot sue. Stranger to a contract cannot sue, but stranger to a consideration can sue. Sir, what is stranger to a consideration can sue? See, stranger to a contract cannot sue. There are some exceptions that stranger to a contract cannot sue. Normally, stranger to a contract cannot sue. Okay, but sometimes stranger to a contract also can sue. Why stranger to a contract can sue? Let's see the exceptions. Okay, let's see the exceptions. There are totally 7 exceptions to this. How many? 7. First one, beneficiaries in case of a trust. Beneficiaries in case of a trust. One by one, I will explain. Okay. See, A is a grandfather. B is a grandson. C is a advocate. Okay. A grandfather has huge properties. Okay. He has written a trust saying to C that, Mr. C, my grandson is there. I may be passing by, means he will be dying, maybe in another 6 months or 1 year. Beyond that, I can't. Therefore, from this huge properties, income will generate that income, use it for the benefit of my grandchild, Mr. B. Okay. Contract is entered into between whom and whom? A and C. Who don't know about it? B is a stranger to this. Contract entered into between A and B, A and C. A said that, C, I am giving you house property. From this rent will come. Use it for the benefit of my grandchild. If I on my demise, like that, he wrote a trust. Okay. Now who is A? A is called as a settler. A is called as a, see, there are 2 parties. There are 2 parties. I will show you. Okay. First see this. A is called as settler. There are 2 names for A. One is author or a settler. You can call them in any way. C is called as trustee. C is called as a trustee. Means the trustworthy person. Okay. B is called as beneficiary. B is called as beneficiary. Now tell me, normally to this, what happened? Stranger to the contract. Who is a stranger to the contract? B is a stranger to the contract. Correct? Because agreement is between A and C. B is a grandchild having an age of 11 years. All that fellow don't even know that there is an agreement between A and C. Okay, now see the story. A died. C is not using the properties for the benefit of B. He is eating for himself, like so many trustees in India today. Okay, he is eating. Can B sue Mr. C or not? Yes. B, you are a stranger? No. B is a stranger to the contract. Pakka. But he is not a stranger to the consideration. The benefit should go to C as per the agreement. Therefore, a stranger to contract cannot sue, but a stranger to consideration can sue. My grandfather entered into contract with you. Pakka. I don't know about all this. But for whose benefit he entered into contract with you? My benefit only, na? So I am a stranger to the contract, but I am not a stranger to the consideration. Therefore, in these cases, I can sue you. Okay. So an agreement to create a trust that can be enforced by the beneficiary, though he is not a party to the contract between settler and the trustee. Now, could you understand clearly or not? I want one reply. For the hard work that we are putting, are you really understanding the concept clearly or not? Everybody. Understood the concept clearly? Okay, next. Okay. Next one. So beneficiaries to a trust. Next, written family settlements. Written, not oral. Written family settlement. Sir, what is written family settlement? Question will arise, na? Listen. See, there is a Hindu undivided family. Two brothers A and B with their mother M. They are living with their children, wife, etc. Okay, it's a family. A with his wife and children. B with his wife and children. Father is not there, mother is existed. Okay. Now this is a family. This family is divided now. Partition. Partition. Who should take care of her? Take care of their mother? A or B should take care. Correct? Great children these are. Okay. These people said that no. Let's keep her in an old age home. Seriously, this case happened. These kind of sons will die anyway very soon. But it has happened actually. So A, B decided, I can't take care, you can't take care, let her keep in an old age home. Great people. Okay. So this is the scenario. What happened? A and B. Okay. A and B entered into agreement saying that you pay 10,000, I will pay 10,000. Let us give 20,000 to her every month. That's it. That's a consideration for her. That is a consideration that we can give to our mother. Great people. So they said that 20,000 every month let us send to her. You 10,000, mine 10,000. Okay. Let's send. Is agreed. Who agreed? A, B agreed. Contract is between whom and whom? A and B. Family settlement. Okay. They have written an agreement also. Okay. 1 month completed, 2 months completed, 3rd month onwards, A stopped giving that 10,000 also. Okay. Seeing him, B also got motivated. Okay. No relation, nothing. Money important, these people. So what they said, okay, if you don't pay, I will not pay. Why I should pay 10,000? B also stopped giving 10,000. She came to know about it. Anyway, you are not taking care. At least for livelihood, she require money. That also they are not giving. Irritated, she went to court. She filed a complaint against A and B, saying that these two idiots unnecessarily gave birth to these two idiots. These two people are not giving me even that 20,000 for my livelihood. What I should do? I should beg on roads for giving birth to them. Like that, she cried in the court. Court gave a judgment. A and B are there now. These two people brought one idiot lawyer along with them. He said that you are not a party to the contract. In the written agreement, you are not a party. Therefore, you cannot sue them. Court said that. Advocate, first, sabar karo. Next, A and B, idiots, you also sabar karo. Therefore, what court has given a judgment? Court simply said that M is not a party to the contract. Pakka, 100%. But she is a party to the consideration. As the A and B agreement, 20,000 to whom you should pay? To B. And the consideration is flowing to whom? M. Therefore, M has all rights to sue both A and B. Understood the point of family settlement clearly? Yeah? Reply. Everyone understood clearly? I think everyone understood. Perfect. Thank you. Next one. So, what is the first one? Beneficiaries. Next one, return family settlements. Two brothers X and Y agreed to pay an allowance of rupees 20,000 to her mother on partition of joint property. But later they failed to pay. Mother, even though stranger to the contract, can sue the sons. Let her do. Very good. Next, in case of certain marriage contracts and arrangements, a provision may be made for the benefit of a person. He may file a suit though he is not a party to the agreement. Okay, same. Even though he is not a party to a contract, he can still sue. Read the paragraph first. A provision may be made. Read that first. Okay, listen. What is this concept again? A married B. Okay. B's father is C. Okay. A married to B. Mr. A, Miss B, both got married. Yeah. Okay. Wow. Her father is C. Okay. After marriage, this A started domestic violence against B. This poor girl, she went to her father and said, this idiot is not treating me properly. Let us file a case. C immediately went to court, filed a case against this idiot. This fellow is not a human being. He is ill-treating her at home. Domestic violence. Take an action against her, against him. Like that, C filed a complaint in court. For the first time, the court do not desert both the people. Desert means divorce. Court will not generally do that. They will tell, Array, why you are doing like that? You are an animal or a human being. Why you are ill-treating her? They try to give a counseling. Okay. Counseling, if they don't listen, there is no other option except to desert and divorce. So for the first time, court will not do. The court intention was not to separate people. The court intention was to make the people united only. But even after reasonable efforts, if both are not listening to each other, means there is no other option. So what happened in this case? Mr. A ill-treated his wife. She went to C and cried. Obviously, father, he went to court and filed a complaint against this idiot. A said that, sorry, never I will do again. Auntie promise, uncle promise, never I will do in my life again. So I'm promising on everyone. So please send her. If I really do any domestic violence again, I will pay 1 lakh rupees. Like that, written agreement entered. Okay, what? Story over. Now what happened? She went home. That he will take care. Again, he started doing the same domestic violence against her. Okay, what? Okay, now listen. Who entered into agreement? A. Entered into agreement with whom? C. His father, saying that I will not ill-treat your daughter again, because C filed a complaint in court. So you should agree with C only. He said that I will never ill-treat your daughter again. I will take care of her. So you can believe me. If I really don't, I will pay 1 lakh per month for consideration or a compensation. Agreed written with C. Over. 1 month completed. After 1 month, again, this idiot started doing the same nonsense with her. Again, she cried with her father, and he again enforced the contract. Now, B directly went to the court and said, pay that 1 lakh to me. Nicely she has done. B went directly to court and said, pay me 1 lakh. A said that, hey, you don't have any right to ask me 1 lakh. Contract is between you, me and your father. He should come and ask. Then she said, I also learned law. Okay. In law, there is a concept called as stranger to a contract cannot sue on a contract, but stranger to a consideration can sue. Here, a 1 lakh consideration is for me only. So I can sue you in the court. Court also decided that, yes, she can sue. So a provision may be made for the benefit of a person. He may file a suit, though he is not a party to the agreement. Agreement is between A and C. But B is a party to consideration. They can sue on the contract. Everybody now reply. Understood the third one or not? Okay, well, everyone. Okay. Next one. 3 points completed now. Fourth one. Assignment of a contract. What is the next one? Assignment of a contract. What is this assignment of contract? Let us try to understand clearly. Okay. What is the assignment of contract? Where there is an assignment of a contract, the assignee can enforce the contract for various benefits that would accrue. Sir, what is an assignment? Assignment means transferring the rights or duties to some other person. Okay. Transfer of rights and duties to some other person. Same example. A, B entered into contract to provide benefits to C. A, B entered into contract to provide benefits to C. Now, C is the assignee of the benefits. Though he is not a party to the contract, C can sue. Next. Acknowledgement of debts. What is the next one? Acknowledgement of debts. In case of part performance of a contractual obligations, or where there is an acknowledgement of liability on account of estoppel, a third party can sue for the benefits. Read this point clearly. I'm making it full screen. Read the point clearly. Okay, see, in case of part performance, part performance of contractual obligation, or where there is an acknowledgement of liability on account of estoppel, a third party can sue for the benefit. Let us say, for example, A gives rupees 25,000 to be given to C. Remember the example. A gives rupees 25,000 to B, okay, to give to C. And B informs C that B is holding on behalf of C, but subsequently refuses to pay C. Then C can sue and enforce his claim. See, A gave money to B, saying that B pay this money to C. B said to C, I'm holding money given by A on your behalf. I will pay you. But later B did not pay C. B did not pay C. Therefore, C can directly sue B, though he is not having any contract with him, because he is having the consideration rights. Okay. Next, where a piece of covenants to the land. Covenants means parties in the agreement. Okay, covenant means agreement. Where a piece of land which is sold to the buyer with certain covenants, means the terms and conditions relating to the land, and the buyer is kept on notice of the covenants with the certain duties. Okay, there the successors of the seller can enforce these covenants. Successor of the seller can enforce the covenants. So read it properly once. Read it properly once. Okay, I'm not going to take much of your time. I will explain this in a proper way. See, there is a piece of land belonging to A. B came, buyer. A said to B very clearly, in this plot of land, totally this is a 100 square yards land. How much? 100 square yards of land. In this 100 square yards of land, 20 square yards belonging also to my sons. 80 square yards, I will give undisputed ownership to you. Okay, 20 square yards, my sons are also having a right on this. Entered into agreement. Okay, na? A sold property to B. Okay, A sold property to B, saying that term and condition, in this 20 square yards belonging to my children. Over. Children don't know about it. Just is an agreement between A and B. Children grown up, they became major, they came to know about this. Can they enforce? Yes. Though they are not party to contract between A and B, benefit is flowing to them now, consideration. They are also enforceable. Next. Contracts made by the agent. Contracts made by the agent. The principal can enforce the contract entered by the agent where the agent has acted within the scope of his authority and in the name of principal. Okay. Sir, what is this concept? Agency chapter already we completed. Na? There what you learned, what is the moral of the story? If agent does anything with the third party, principal will be liable to the third party. Actually, they don't know who is the principal. But still principal will be liable because he is not a party to a contract, but the party to the consideration of a contract. Next. No consideration, no contract. Normally what will happen if there is no consideration, there is no contract. But there are exceptions to that. 5 minutes I will complete this and close. Okay, first one. Out of natural love and affection. Simply to tell, a father gifting to his son or a daughter. Okay, a father gifting it to a son or a daughter. What is this? Out of a natural love and affection they will give. Okay, so where an agreement is expressed in writing and registered under a law for the time being in force for registration of documents and is made on account of natural love and affection between the parties standing in near relation to each other is enforceable even if there is no consideration. Nearness of relation, however, depends not necessarily imply love and affection. Sorry, main concept let us understand. First thing, any agreement written between, simply to tell, father said to daughter that this house property I am giving it to you. Gift deed was written. What is written? Gift deed was written. And that gift deed is registered. Okay, but he is not giving the property. Now she can sue. So social contracts are not valid, pakka. But here the problem is, it is no more a social contract. It is in writing and registered under any law. that he has to give gift to her daughter. If he do not, she can also sue. So even though there is no consideration, there is a contract created because of out of natural love and affection. Next, compensation paid for past voluntary services. Okay, see, a promise to compensate wholly or in part for past voluntary services rendered by someone to the promisor does not require consideration for being enforced. In order that promise to pay for past voluntary services is binding, the following essential factors must exist. So, past voluntary services. What do you mean voluntary service? He did not ask me to do anything. I only have done in the past. Okay. But on that also, there can be a consideration. Actually, I did not expect anything. I have done. But as a responsible person, you should pay something. See, services should have been rendered voluntarily. Okay. Services must have been rendered for the promisor. Promisor must be in existence at the time services are rendered. The promisor must have intended to compensate the promisee. Sir, all these are not required, sir. Tell me one good example. I have given super example. P finds R's wallet. Okay, R's wallet and give to him. R promises to give P rupees 10,000. This is a valid contract. Why? Listen, originally between you and me, there is no contract. You lost a wallet on a road. I found it. I saw your Aadhaar card as the details. I went to the department and I asked phone number. I got your number. I called you. You picked up. You said that, sir, please give the wallet. I will pay you 10,000. Now a voluntary act that I have done. Then you fix the consideration of 10,000. This is a valid contract. Means originally there is no contract. There is no consideration. When I found the wallet, no consideration. When I gave it to you, no consideration. Later you said. So even though there is no consideration, there is a contract. Okay. So a promise to compensate for the past voluntary services rendered by someone to the promisor does not require any consideration to be enforced. Okay. So I have done voluntary. Wallet is found. I can keep it with me. But voluntarily I brought it to you. That was done already. For that, if you are fixing consideration, no problem. There is no consideration originally, but still there exists a contract. Okay. But 4 conditions. Very, very important. Services should be rendered voluntarily. Means what? You did not ask me, but I only have done as a responsible person. And I should do only for that person. Next. Promisor must be existed at that time. Yes, he is existed in our example. Okay. And promisor should have an intention to compensate. He said that, hey, it is your responsibility to give back my wallet. You cannot ask for money, means you can't sue him. If he intends to pay something, then you must get the consideration. Next. Promise to pay debts barred by limitation. Okay. What do you mean by debts barred by limitation? Listen. I gave you loan, 1 lakh. Pay me within 2 years, I said. 2 years after you did not pay. As per Limitation Act, 3 years, if you do not take any action against him, that's it. That becomes a time barred debt. That fellow is not liable to pay you. That's it. A gave loan to B for 1 year loan. 1 year completed, B did not repay A. 3 years recovery should happen. Action should be taken. Okay, action should be taken. So A did not take any action against B in the next 3 years. That's all. It becomes a time barred debt. Okay, it becomes a time barred. Means consideration is no more there. But B voluntarily said that I will pay you. Even though there is no consideration, now if you agree to pay, contract will be created. Where there is a promise in writing to pay a debt, which was barred by limitation, is a valid without consideration. Means what? Normally consideration you need not pay. Over. Consideration need not be paid. Why? It's a time barred debt. But still you are agreeing to pay na? Yes, that's it. So A indebted to C for rupees 60,000. But the debt is barred by limitation. A gives a written promise to pay 15,000 in final. It is a valid contract. Though it is a time barred debt, being some responsible person, he said, I can't pay entire 4 lakh or 5 lakh, but 50,000 I will pay. Okay, he said, that's it. It's a valid consideration. Next one, bailment. From here, you need not read, just listen to my words. Bailment and pledge already we read. Bailment, there are 2 bailments, gratuitous and non-gratuitous bailment. Gratuitous bailment will be done out of respect, natural love and affection. Consideration not required, but still contract is there. Okay. In case of gifts also same. Next, creation of an agency. Agency also. For example, father is the principal, son is the agent. What consideration they will pay? In agency also consideration is not required. Next, charity. Charity, what does it mean? I said to a charitable organization, I will give you a check of 5 lakh. The moment I promise them, it becomes a contract, though there is no consideration because it's a charity. Okay, so with this, we completed one very important chapter, consideration. Everybody, please give a reply. Have you all got a clarity? Next thing, what you have to do, next half an hour, open my question bank. There are around 8 to 10 different questions that were tested in the recent RTP, MTPs and exams. Do all the 8 or 9 questions that were given. You will become perfect. 5 marks is yours. Okay, half an hour you spend. That's all. More than that also not required. Everyone got a clarity on the chapter, consideration? Okay, like this, I will also upload one video on my channel, and I will also give to i-Comm also. They will also publish to you. So that particular will be on chapter 5 and 6. Chapter 5 and 6. Okay, there is one area called as a contingent quasi contracts, breach of contract. Those 2 chapters also I will put 45 minutes and 45 minutes each. Okay, such that you will become perfect. Okay, well? Yeah. I think I will do one thing. I will give the access to the PDF of a question bank, that particular contract actor. You can visit to that, or you can see study material or something like that also you can do. Okay, well? No worry. Okay, all the very best, everyone. Prepare well. Consideration, chapter 5th chapter, 6th chapter, don't leave. 2, 5, 6. One day before examination, I will only come for revision for 2 hours. First chapter also will cover. That's it. You will definitely get that 60 plus in the paper. No worry. Okay. Bye bye. All the very best. Prepare well.